Okay, thank you so much. I believe we are ready to start. I'm Anna de Robilant, and I will be moderating this panel. Thank you so much for being here and for attending the second plenary panel in this conference titled Comparative Legal Histories. Before I introduce our speakers, I would like to thank Professor Maximo Langer from UCLA for all the amazing work he has done to plan this conference. This was a conference that was originally supposed to be hosted in person at BU, where I teach this fall. And unfortunately, due to the budgetary cuts related to the COVID emergency, this couldn't happen. So Maximo stepped in very generously and devoted a great amount of time to this, and I'm extremely grateful. I feel a little bit guilty, Maximo, but I'm extremely grateful.
Thank you.
So the title of this panel is Comparative Legal Histories. Comparative legal history is obviously a very important critical tool, that allows us to sort of balance the historian, to balance the general and the particular, the larger structural explanation, and the sort of more hagiographic and anecdotal and fine-grained account. But comparative legal history is done in very different ways. And in this panel, we'll get an introduction to very different modes of writing comparative legal history. There's comparative legal history that is more along the lines of socioeconomic history. There's comparative intellectual history, and there are different modes of writing comparative intellectual history, from textualist to contextualist. And then there's a burgeoning field of global intellectual history. So it's a very rich field, and we'll get exposure to this richness here today in the panel. And now, without further ado, I will introduce the speakers. So we'll go in alphabetical order. Our first speaker is Professor Lauren Benton. Professor Benton is the Barton M. Biggs Professor of History and Professor of Law at Yale. Most of her scholarly work focuses on the history of empires and the law. She has published extensively, and I'll mention my favorite book among the many 4 books that Professor Benton has published, which is A Search for Sovereignty, Law and Geography in European Empires, 1400-1900. We are delighted to have you here today, Professor Lauren Benton. Thank you so much. Our second speaker is Professor Ariela Gross, who is the John and Alice Sharp Professor of Law and History at USC, University of Southern California, Gould School of Law. Professor Gross' work focuses on the history of race and slavery in the United States. And she has a book just out, right, with Professor Alejandro de la Fuente, titled Becoming Free, Becoming Black, Race, Freedom, Law in Cuba, Virginia, and Louisiana. Professor Marie Kim is Professor of History at St. Cloud University Department of History. Professor Marie Kim is a specialist in Japanese, Korean, and French law and legal history, and her most recent book, 2019, is titled Constitutional Transition and the Travail of Judges. And finally, Professor Timothy Lovelace, who is the John Hope Franklin Research Scholar and Professor of Law at Duke University School of Law. He's an expert in how the civil rights movement in the United States has helped shape the international human rights discourse and law. And the title of his forthcoming book, am I correct, spring 2020 is "The World is on Our Side, the United States and the UN Race Convention." So thank you so much to these four fabulous speakers for being here with us today. And without further ado, Professor Lauren Benton, you're the first to go.
Thanks very much. Thanks for the opportunity to do this, and thanks for that generous introduction, Anna. Discussions of comparative history, I have noted, often devolve into these sorts of simplistic debates about whether it's better to analyze differences or similarities. And I think these debates tend to be of questionable benefit to comparative legal history. When historians present findings emphasizing similarities across historical settings, respondents often react by enumerating actual differences, and they even accuse lumpers of distorting historical evidence in the service of theoretical agendas. And when historians analyze differences, they open themselves to criticisms that they're merely producing parallel narratives, or at most perhaps tracing patterns of divergence. Both of those exercises can answer important historical questions, but they're fairly weak prompts for theoretical insights or accounts of generalizable patterns of change. So to help move beyond this kind of fatuous characterization of comparative legal scholars as splitters or lumpers, I want to draw attention to a third approach that I think is implicit in what a lot of us do, and it's one that I'm calling comparison by refraction. This is an approach that searches for useful generalizations by using the careful historical analysis of one case to highlight elements that are otherwise obscured or partially obscured in other cases. The exercise can transcend questions of similarity and difference to illuminate structural conditions, patterns of legal conflict and change, or widespread legal processes. So I'm going to illustrate the approach today by providing in 15 minutes a whirlwind, and I might add quick and dirty, history of rights in empire. So I'll argue that an analysis via refraction illuminates the importance within the history of rights in empire, of representations of authority and order. The approach drives analysis away from a focus on natural rights as an influential circulating discourse. It also goes further in showing what Lisa Ford and I have called variegated rights regimes as a structural feature of empires, and it points to a set of specific historical mechanisms shaping those regimes. So I'm going to begin with what might seem like an outlier example. On purpose, outlier examples tend to be pretty helpful in this kind of analysis. So legal historians of the Russian Empire have recently worked to explode the myth that it was not an empire of law. They've uncovered previously little known histories of active participation in legal disputes and processes by local elites, peasants, and other groups. And then going further, studies of the Russian Empire's legal politics have highlighted distinctive qualities in the empire's definition of rights. So Jane Burbank has argued forcefully that Russian imperial history does not align with narratives from Western Europe of the rise of a universal definition of rights. Instead, the Russian imperial rights regime, as she calls it, featured the persistence of a system of unequal rights that were distributed to groups according to their position within the imperial order. According to Burbank, then, rights could not be had, and I'm quoting, rights could not be had except through the state and through official identification as a member of one or another kind of collectivity. Now, the first thing one might notice about this account is that it fits rather better than Burbank suggests with trends in recent studies of the legal politics of law and empire. Jennifer Pitts has challenged earlier characterizations of an 18th century drive toward a universal understanding of rights in Europe, and her analysis actually follows on Moyne's previous characterization of the long persistence of definitions of rights as civic and positional rather than universal. So can we go beyond noting this family resemblance? I want to suggest that by using the Russian imperial rights regime as a prompt to emphasize order over rights, we can also point to patterns of imperial legal politics that sort of show us how they centered on the scope of imperial authority, the jurisdiction of local elites, and a discourse of the common good. So I think it's useful to begin with helpful reassessments of early European framing of questions of rights. Historians of Roman, medieval, and scholastic legal thought have recently emphasized the way notions of right use were bound to dominium. While we might think of these assertions as operating only in the realm of political theology, the connection to legal systems was always inherent. The imagined function of civic law, according to Annabel Brett, was, quote, to fix persons and things in relation of dominium and servitude to one another, and to regulate a vast mesh of interlocking dominia. Rather than positing new ideas of right grounded in liberty in ways that laid the foundations for modern views of subjective individual rights, political theologians such as Francisco de Vitoria hewed closely to older associations of right and dominion. And in the process, they foregrounded questions about the authority of the prince in multiple ways. So first, the approach drove discussions of natural right toward a singular emphasis on self-preservation. How was self-preservation significant in framing and defining authority? Well, individuals could not simply relinquish dominion over their households or themselves. They had to preserve both. They could offer their consent to a superior to act for them in this regard, and late scholastics indeed proposed that sovereign's authority flowed by necessity from the consent of the people. And the prince, too, had to act to preserve the political community. Good acts, by definition, promoted the common good or the general welfare. And second, it followed that if the monarch held power through the grant of potestas from the political community, the community remained the natural and permanent seat of potestas. So more specifically, according to Vitoria, the king did not receive a grant of potestas in full, but instead acquired by grant of the people the capacity to compel others to act in particular ways. This was not full sovereignty, but in Latin, auctoritas. So the main point to highlight here is that the monarch's authority, akin to jurisdiction in many respects, translated to a right to order and organize the rights of subjects and subject groups. And such constructions of rights were inseparable from duties. Obligations, of course, flowed in both directions, from subjects to ruler and from ruler to subjects. Now, European imperial ventures echoed this melding of authority and rights, and they also placed powerful and immediate strain on questions about the reach and durability of crown authority and its role in assigning and protecting rights. So I've only got time to sort of cite a few highlights of the many faceted projects of research on this point. So early English colonizing, we learn, unleashed waves of anxiety at home about whether protections of English liberties could extend beyond the English realm. Within the composite polity of Britain, liberties were not identical across borders, and there was no clear assumption that subjects could carry them into other territories. In Calvin's case, Edward Coke famously argued for limiting the reach of common law courts beyond England, but Coke also fused the problem of rights to the question of authority. As Daniel Hulsebach has succinctly put it, for Coke, remedy defined right. So Coke focused on the question of whether remedial writs of the common law were available to English subjects outside England. Rather than fixing the imperial constitution, Coke instead helped to frame continuing controversy over imperial authority, local legal autonomy, and the qualities of fundamental law that could be seen as connecting parts of the empire to a whole. Now, rights talk continued to be deeply grounded in representations of imperial order. John Philip Reed and other scholars of the imperial constitution have argued that natural rights talks was relatively unimportant compared with debates about the protections that different assemblages of authority offered to English liberties. In focusing particular attention on the reach of crown and imperial authority, rights talk by English settlers was actually echoed by Native American representations of Indians as loyal subjects of the crown who might also appeal to the crown for protection. And these positions were not at all inconsistent with rebellion. There are plenty of examples of their combination, for example, in Metacom's direct appeals to the crown in King Philip's War. So more generally, the relative unimportance of natural law constructions of rights continued even into the midst of revolutionary mobilization. As David Armitage notes in his analysis of the Declaration of Independence, the individual natural rights language that we later came to consider the central message of the Declaration was less important in its immediate context than the assertion of the right, grounded in natural and positive law, to break with metropolitan authority. On its face, Iberian imperial legal politics developed in very different registers. We can't, in this context, point to a prominent case like Calvin's case. The idea appeared settled that Castilian law extended to all New World Spanish territories. And yet we find a wide range of legal conflicts activating questions of authority and reinforcing the uneven distribution of rights and the way they flowed from Crown authority. So both sojourning subjects and conquered indigenous subjects in the Spanish Empire retained the right to appeal directly to the Crown for relief from harsh or arbitrary treatment by the Crown's agents or others. Native Americans not only petitioned the Crown, but also litigated in Spanish courts, including a new jurisdiction that identified them as subjects requiring special royal protection. As Primo and Yanakanis have recently argued, Indians also sought to preserve native jurisdiction within the plural legal order. Now, as in the Crown colonies, as in English colonies, jurisdictional politics replicated appeals to the capacity and duty of the Crown to provide protection. The dynamic extended into periods of open rebellion and revolution. Late 18th century Andes rebels combined appeals to Crown protection with violence against local authorities, as Sergio Cyrilnikov has shown, and royalism among Indians persisted into the multi-sided wars of the early 19th century, as Echeverria has recently shown for Gran Colombia. In decades-long upheavals following the French invasion of the Iberian Peninsula, Creoles turned with new enthusiasm to the old idea that potestas resided fundamentally in the community. They emphasized that they were not seizing sovereignty, but instead assuming their undisturbed right to exercise sovereignty or part sovereignty in the absence of an effective monarchy. And I'm going to skip over some examples of this, although I'll be happy to talk about them in the Q&A. Because I want to get to my next point about the way some of these themes appeared in the politics of slavery and abolition, and I hope that this operates in some way as a good preface to Ariela Gross's talk. So, you know, we often think of revolutionary Haiti as a singular case, but the legal politics of the Haitian Revolution actually fits pretty well within the framework that I've just described. I think the best, quickest example of this is Malik Gacham's effort to track the way in the earliest stages of the revolution, leaders imagined preserving the Code Noir and then simply reforming it. Although revolutionaries recognized that the code had served as an instrument of repression in the Ancien regime, they also recognized in its structure the clear right of public authority to curb the private power of slave and plantation owners, or the semi-private power, however you want to think about it. One could imagine then radically shrinking the jurisdictional capacity of planters in a very new regime. Now, so I want to underline the centrality of jurisdictional tensions in the legal politics of slavery and abolition, because I think this framing is sometimes lost in the search for the origins of universal rights talk in Atlantic revolutions and their aftermath. As Lisa Ford and I have shown in our book on early 19th century British imperial reforms, abolitionists like James Stephens saw strengthening the power of the imperial government as the key to ending the slave trade and regulating the conditions of slaves. The excessive power of slave owners nurtured petty despotism, and that was in turn represented by abolitionists as the greatest threat to imperial constitutional order. It was not the rights of slaves or even their suffering that received the most sustained attention from reformers in this legal context or this legal register. Similarly, the abolition regime targeted the property rights of slave traders rather than focusing on the liberation of enslaved people. So adapting prize law, mixed commissions adjudicated slave ship captures in ways that continued to characterize captives as cargo. The courts could not mete out criminal punishment for traitors, and they funneled captives into other regions of domination and exploitation. And the result was, as Ford and I have argued, a patchy prohibition regime that can hardly be regarded, as some have suggested, as the makings of human rights law. In Jamaica, to make a similar point, but in a different way, in British India and in other parts of the empire, controversies over the meaning of martial law and access to jury trials, these were two of the empire's hot-button legal issues, were increasingly framed as questions of procedural justice. So the call for procedural reform emphasized the imperative to extend a degree of protection of the law to all, but not equality before the law. So taking into account these findings of a consistent emphasis of order over rights, or of reading rights through the lens of order, we can turn back to the Russian Empire with a different perspective from the one with which we began. To be sure, the Russian case remains provocative, but its distinctions appear decidedly less sharp. European overseas empires also produced imperial rights regimes predicated on the imperial sovereign's role in the protection and regulation of unequal and situationally determined distributions of rights. Natural rights were deployed less than older accounts have suggested, and pointedly in the context of fixing relations of authority. More often than not, talk of order trumped rights talk or framed it in specific and limited ways. Yet comparative analysis is not just an exercise of lumping, I've contended. It also illuminates generalizable patterns that I think go to the very heart of historical questions about rights and order in empire. And my overview has drawn out three such insights, at least I hope it has. The first finds in empires an intensified, institutionally grounded referencing of the legal authority of imperial governments, of crown authority in particular. The second points to the consistency with which debates about imperial authority centered on conflicts over the jurisdictional capacities of colonial and local elites, right? This jurisdictional tension between imperial power and colonial elites turns out to be overwhelmingly important. Third, these patterns of conflict meant that rights talk was frequently framed by claims that legal actors were promoting the general welfare or the common good. I haven't been able to talk as much about that point, but it's one I'd be happy to elaborate on in the Q&A. So these observations emerge from an analysis that juxtaposes cases using the bright contours of construction of rights in one case to illuminate in others a similarly embedded relation between rights and authority. Beyond splitting and lumping, we can add, I think, substance and nuance to histories of variegated rights regimes and empires through a comparative analysis of refraction. I think I even stayed within my time. Thank you.
Thank you so much, Professor Benton. Before we move to our next speaker, I just want to say something that I omitted to mention at the beginning. We'll have half an hour for Q&A, and so save your questions, and you will be submitting your questions through the Q&A function. Okay, so our second speaker is Professor Ariela. Without further ado.
Great. Thank you so much, and I'm sorry to have jumped on late. Every kind of technological mess up I could have, but I'm going to try risking another with sharing my screen. Let's see if this works. Uh-oh. Here we go. Can you see my screen? Yes, okay, that's good. Now I just need to get my view back. Here we go. It's really a pleasure to be here and participate in this conversation about comparative legal history. I want to thank Maximo for inviting me to be on the panel, and I'm especially thrilled to follow, although intimidated, to follow on Lori's coattails. And especially because coming from the perspective of legal history, comparative legal history, I would say, hasn't been particularly in vogue. And to the extent that in the last decade or so, many of legal historians have turned their focus more globally and transnationally, that there hasn't necessarily been the same attention to specifically comparative questions, although obviously the people on this panel are the marvelous exception to that. But in the study of race and slavery in particular, many of the great comparative works are mid-20th century, and in the study of race and slavery, so many, the wave of kind of new social histories that followed in the latter half of the 20th century and in the last several decades, kind of socio-legal histories have been more micro-historical, kind of bottom-up histories, and haven't taken on the same kind of big questions of comparison, particularly when we think about a kind of mid-20th century focus on comparing Latin America and Anglo-America that was so prevalent. And so I think this is a really interesting moment as some of us are turning back to those questions, but still trying, at least in Alejandro's and my case, to return to those questions from a more bottom-up perspective on legal history. And so our book, Becoming Free, Becoming Black, tells the story of enslaved people who took advantage of openings in the law to claim freedom for themselves and their families, and tries to maintain a focus on the way ordinary people were making claims on legal institutions and participating in legal processes that shaped the institution of slavery and created regimes of race. Now, I think when we started out, we thought we might be doing a very kind of comprehensive look at the comparative law of slavery, and ended up writing a very different book that more focused on the law of freedom, on the ways in which people brought suits for and otherwise claimed freedom through the law and the regulation of free people of color. And that's in part because of the way our research went as we tried to answer some comparative questions. So hang on. So the question that we're asking, well, I want to say first, right, we chose 3 places to compare, and we tried to think about, in taking this comparative approach, recognizing that we weren't dealing with 3 hermetically sealed jurisdictions totally separate from one another, but one situated in the same Atlantic world where people, ideas, legal doctrines are circulating freely among them. And so we chose 3 places that have many connections that we try to draw out in the book, but all 3 become full plantation slave societies roughly contemporaneously, with rather similar economies, although each is settled at a different time. And Cuba and Virginia are representative of Spanish and British colonies. Louisiana gave us the opportunity to study a hybrid society that began as a French colony, became Spanish, ended up part of the United States. And And the key question that we ask in the book is why it is that in all three of these places where colonists from Spain, from Britain, and from France all begin by putting into place in the law distinctions based on race, equating African descent with degradation and slave status. And in fact, even earlier in Havana than in Louisiana or Virginia, the Spanish colonists in Cuba have experience with enslavement of Africans in the slaveholding capitals of the Mediterranean. They come with both social and legal precedents for drawing the connection between the category of Black and slave status, and so they kind of have a head start ideologically, legally, socially, but in all three places that race-making project gets well underway by the early 18th century, but by 1860. They look very different. A free person of color in Havana could be part of public life, but in Louisiana or Virginia is being excluded from public life, and citizenship is becoming tied to whiteness in a way it isn't in Cuba. And so our answer ended up being that it was really the law of freedom and not the law of slavery that was determining these different trajectories in the regimes of race. And so our story does begin with an important difference in the legal tradition, in particular, the fact that manumission, whether you might say the right to claim freedom, but really the right of an owner to bestow freedom on an enslaved person, is never limited in Cuba. It's never tied to race in the way it increasingly is in Virginia and Louisiana. And that's a very important difference that we see in the colonial period. But that story takes many twists and turns. It doesn't end there, because we really try to look at change over time. So, for example, a place like Virginia is quite open in the 17th century, no limits on manumission, big, relatively large populations of free people of color who were able to make legal claims that are already impossible in Cuba, for example, such as a claim to freedom based on Christian baptism or a white father. But by the early 18th century has become much more restrictive. So we see these kind of twists and turns. The book tries to show how important in pushing legal change were the initiatives of enslaved people themselves. From the beginning, enslaved and free people of African ancestry pushed on the law to claim freedom and carve out new rights of citizenship. We show that the politics of white men's democracy in the American Republic, where slaveholders had to appeal to non-slaveholding white people, made the position of free people of color especially precarious in a way it did not in Cuba. And we identify the Age of Revolution as a key moment in this divergence, but not in the way you might expect. And here's, I think, a place where what we were trying to write about really intersects with what Lori is talking about. In some ways, it's a moment in which freedom and rights discourse expanding all over the Americas, and yet key differences are already developing, and to a great extent, it's a moment, and maybe I'll jump forward for a second here, where on the one hand, you know, the Haitian Revolution and its example both inspires enslaved and free people of color across the Atlantic world, strikes fear in the hearts of enslavers across the Atlantic world. But the expansion of freedom means something quite different in the Spanish Empire and in the US Republic. And one of the things that we try to trace is the way that many of the opportunities for freedom that enslaved people take advantage of are the result of retrenchment and reform efforts rather than you know, intended to expand freedom. And this is true certainly in the Spanish Empire, where you know, some of the kinds of changes Lori talked about, sort of that have to do with the politics of the crown and the and colonial elites who are slaveholding elites. So the creation of official positions for enslaved people to be able to appeal to the crown provide greater opportunities to expand the practice of self-purchase, coartation, changes in the taxation regime also helps expand these practices. In the US case, one of the ways in which freedom suits expand during the age of revolution is through kind of an unintended effect of laws that were in Virginia that limit the importation of slaves into the state. They're entirely about kind of protecting the domestic slave market, but enslaved people take advantage of the penalty for wrongful importation being emancipation to make freedom claims. More fundamentally, communities of free people of color in Cuba and in Spanish Louisiana owe their existence to legal understandings and customary practices that are anchored in traditions of the ancien regime. Those who become free become members of stratified societies, and Black freedom didn't imply equality or Republican rights. But in Virginia, for example, during the Age of Revolution, the expansion of manumission and freedom suits gets tied in political debate to questions of citizenship and to the expansion of voting rights and other kinds of political rights that are happening at that time to all white men. And so you see the kind of, for example, petitions that go from white citizens to the General Assembly in Virginia. This is a petition for the removal of free people of color from Northampton County, which is a Eastern Shore county in Virginia with a big population of free people of color. The petitions say we need to end manumission, which they call partial emancipation, and connect it to general emancipation. This partial emancipation could lead to the end of slavery, and no one is really making that connection in Cuba. After Nat Turner's rebellion in 1831, the political will of white people to exclude free Black people intensified, and the response to threats of rebellion and to Northern abolitionist demand for immediate emancipation, the response is a defense by white Southerners of slavery as a positive good, and to galvanize the support of non-slaveholding white Southerners, cement white solidarity by defining citizenship and voting rights along racial lines. and free people of color become increasingly anomalous and even dangerous to the polity. And so that's why, you know, colonization efforts that sought to remove free Black people to a distant location in Africa prosper in 19th century Virginia and Louisiana, which had changed hands to the United States by this time, but not in Cuba, where efforts to deport free people of color are limited to the emancipados, slaves captured by the British Navy, and free people of color continue to play an important part in militias and confraternities and other aspects of public life. That's also why Virginia and Louisiana act in the 19th century, especially in the 1850s, to end the possibility of manumission, of self-purchase, or freedom suits. By 1860, free people of color in Virginia and Louisiana are increasingly forced to leave the state upon emancipation or live under the threat of prosecution. A few petition for exemption from these onerous laws by winning a certificate that they were, quote, not a Negro. And a handful even chose voluntary re-enslavement in order to remain in their homeland with their families. Free people of color continue to claim freedom in court. They fought tenaciously for the basic rights to a homeland, to remain close to friends and family, to live in their communities of origin. In Louisiana, they continue to draw on Spanish legal traditions to make claims, for example, based on coartación contracts, such as this case of the hatter, Francois, suing his owner, Lebrano, and making a claim that had been successful in Cuba, for example, that by having paid 5/8 of his price, he now owned 5/8 of himself and therefore should be paid wages for 5/8 of his time. That's the kind of right that Cuban enslaved people who were coartado or who had paid a down payment were able to carve out in the 19th century, but was completely unsuccessful in Louisiana. In Louisiana, in Virginia, free people of color saw their militia and schools shut down. Their churches survived only under white leadership. Increasingly contested battles in court over racial identity attested to the growing anxiety over Black citizenship and the need to prove whiteness in order to claim basic rights. And by 1860, Cuba had diverged significantly, not in its legal regime of slavery, but of race. And in that, the initiatives of enslaved people were as important as legal traditions. Communities of free people of color were key, and in Cuba, the community of free people of color had grown to a size that was impossible to ignore, both politically and legally. And I think I didn't keep track, but I think I'm over time, so I'm going to stop there, and I hope we can talk more about some of the really interesting connections among our talks in Q&A. Thank you so much.
Thank you so much, Professor Gross. So our next speaker is Professor Marie Kim. I think you're still muted.
Thank you. I'm a token historian in this panel in the sense of teaching in the history department. I studied European history first before I studied law. So my primary loyalty goes to the history discipline. Still, I'm more at ease writing in Chicago manual style rather than Blue Book. I will divide my talk into two parts. Now, first, I will talk about the current state of legal history scholarship of early modern France. And after a brief overview, then I will discuss the history of custom as law, how the concept of custom as a source of law was born in Europe, and then how it traveled to East Asia. Customary law is, of course, a unique phenomenon of a European legal tradition. France was governed by custom for 600 years before it had a civil code. In traditional East Asia, there was no concept of customary law, and instead China, Korea, and Japan had a very sophisticated law code dating all the way to the 7th century. The concept of custom then spread to East Asia in the late 19th century. Now, first, historiography of law, of customary law of early modern France. There are two distinct methods in doing French legal history. The first is histoire juridique, which focuses on the origins and evolution of the sources of law and the role of doctrine. And the second is histoire littéraire, focusing on the practice of law within cultural and social frameworks. The birth of legal history as an academic field in France dates to 1880 of the Third Republic, when the chair of legal history was created in the Faculty of Law. Until then, there was a ban on teaching history to law apprentices. And the history section in the Agrégation in the law faculties was created in 1896. Allowing history in legal studies was foremost aimed to serve the liberal and the Republican state. And it is interesting to note that it was just about this time that the Dreyfus affair erupted, which led to a sharp ideological division in society and academia. Also, the emergence of the Annales school from the 1930s had the effect of separating historians of law from the dominant group of historians who were heavily invested in social sciences. In the US, from about the 1980s, the scholarly field of early modern France took a definite social and cultural turn. Historians have shied away from the traditional history of the sources of law and institutions, criticizing its alleged top-down or center-focused approach. And they have expanded the notion of law to include all aspects of social norms, symbols, and the literary culture. This postmodern shift toward law as a cultural expression highlights that law is an instrument of dominance, preserving the hierarchies in society of class, gender, or race, for example. And recent works focus on law and gender, or law and family, for example. In this trend of stressing so-called lived law, the importance of customary law has been largely ignored. For example, some historians equate custom with equity, équité, missing the fact that judges in early modern Europe resorted to equity, early modern France resorted to equity in order to get around the custom as well as a statute. Also, they bristle at the idea of the codification of custom. In the US, the law school system, of course, has created a formidable institutional divide, sort of a great wall, separating historians of law teaching in the history department from jurists of history teaching at law schools. And they are largely oblivious of each other's presence. In this situation, history of customary law has been left in a chasm, so to speak, too historical for jurist taste and too legalistic for historians' taste. There are few studies in English on early modern French custom. Now I will turn to the question of custom itself. Customary law is a product of the revival of Roman law. It was medieval doctors who developed the classic theory of custom. Two elements are necessary for custom to obtain the force of law. Now, first, the repetition of a similar act anchored in time immemorial. And then second, opinio juris, or popular consent, that is the belief that the observance of those acts is required. The first element doesn't cause much problem, but the second one does. How can popular consent be ascertained? Well, medieval doctors rather neglected this question, thereby giving rise to the so-called myth of custom. My take is as follows. When people defended and observed the custom, they did so not because it contained the good old norms, which they believed were binding on them from time immemorial, but rather because that particular custom was beneficial to them. For example, granting privileges. Custom is commonly deemed superior to statute because it is something growing from within society as opposed to something imposed from above. It is grounded on the belief that the legitimacy of law comes from the agreement of the people. But there is no reason to think that there was somehow greater consensus in the medieval and early modern times about what social or moral values were acceptable in the community than there is in our own. In the 15th and 16th century France, massive campaigns took place to record and reform local customs by incorporating elements from Roman law. The delicate balance of Roman law and the French custom was of utmost significance. We still see today that scholars of custom in France are divided between roughly partisans of European integration and its opponent, well, something in the line of globalism and nationalism. In any case, the custom in early modern France was soon withdrawn from popular control, and its fate after the revolution is well known. The definite abandonment of a custom came with the codification of civil law in 1804. Moving on to East Asia. East Asia did not have customary law. Custom as law was a concept that Meiji Japan imported from Europe. In 1875, Japan declared custom a source of law. This was the famous Tajukan decree. So some Japanese scholars claimed that they were well ahead of the Swiss, that is the Swiss Civil Code, Article 1, which recognized custom as a source of law, but it was not until 1907, over more than 30 years after the Japanese did. Japan was heavily influenced by Savigny and the German historical school, but its reason for accepting custom as a source of law was purely instrumental for the specific goal of legal modernization. In the name of custom, local practices and usages were interpreted and classified by judges, applying new legal principles and categories. In this way, custom eased the gap between the pre-existing legal order and the new imported system. And we see that this was not very different from what had happened in late medieval France. So from medieval France through Meiji Japan, only 500 years apart, attention to custom took place in the context of external stimulus of alien law and conscious effort of the state to unify legal sources and to centralize the kingdom. As soon as the Japanese created the civil code in 1898, they quickly dropped custom as a source of law. Again, we've already seen that the French and the German did pretty much the same. Well, custom lived, that is, in the colonial context. Now, during the imperial expansion in the 19th and the 20th centuries, Europeans called the custom virtually anything that was not European law. So all native practices, written laws, and the local institutions were called the custom. Now, this obscured the boundaries of law and usages, and it came to hold sway over the use of the term custom in modern East Asia. So custom is an official source of law in Korea and Taiwan today. It attests to the nationalistic desire to highlight their autonomous legal traditions free from the influence of outside law. In conclusion, history of custom provides a valuable framework for a comparative understanding of law across legal systems and traditions in a truly comparative spirit. Spread of civil law through the medium of custom has a long and deep history around the world. Finally, I believe comparative legal historians will do well by paying more attention to this kind of history. Comparative law can do with more empirical evidence and with less theory of anemic social sciences. Some may say the comparative law must, by necessity, have relevance to current issues and problems, but I think there is a history that already has its own enough justification. So historians studying law and jurists studying history should talk across the disciplinary division, so-called the Great Wall between law and history. And sometimes I wish that someone out there could say, well, tear down this wall or something like that. This is why I think this conference is truly meaningful, for me at least. So I thank the organizers for choosing the theme of this conference, and especially Professor Langer for including a bona fide historian in this panel. Thank you.
Thank you so much, Professor Kim. And our last speaker is Professor Lovelace.
Great. Thank you so much for the introduction. Thank you to the organizers of this conference and to my fellow panelists. What I'm going to do today is talk about insights that I've gleaned from my forthcoming book project, The World is on Our Side, the U.S. and the UN Race Convention, which explores how the U.S. Civil Rights Movement helped to shape the development of the International Convention on the Elimination of All Forms of Racial Discrimination, what I simply refer to as either ICERD or the convention in this talk. The convention, as you may know, is one of 9 core treaties of the United Nations and the UN's most comprehensive treaty on race. And so what I'll do today, just in my time, is to talk about 3 things. First, I'll give you some background on the project itself. Second, I'll move into how this project began to engage questions in comparative legal history. And then finally, I'll try to give you a couple of takeaway points, and hopefully this will open up for a larger conversation. So the story in my book begins in late 1963. Remember, 1963 had been an incredible year for civil unrest and racial unrest. In Birmingham, Bull Connor had unleashed snarling police dogs and bruising fire hoses on nonviolent demonstrators, literally children. 4 little girls were murdered in church coming out of Sunday school in Birmingham. In Alabama, George Wallace had closed the schoolhouse doors. Medgar Evers was assassinated that year in 1963. In Cambridge, Maryland, martial law was declared. And in 1963, more than 200,000 Americans marched on Washington demanding jobs and freedom. And so in late 1963, the US State Department began to prepare its delegates for renewed criticism of US race relations. And few UN organs caused State Department officials more consternation than the United Nations Subcommission on the Prevention of Discrimination and Protection of Minorities. The subcommission was a 14-member body of experts, and these experts technically operated in their individual capacities, not as representatives of their national governments. But given the subcommission's very explicit racial mission, the subcommission often transformed into a space where the United States was shamed for talking about democracy abroad, but not practicing democracy at home. And so in response, the State Department began a strategy to help to rebrand American democracy abroad using international human rights law. And so State Department officials selected Morris Abram as the next U.S. member on the subcommission. Morris Abram was no ordinary lawyer. He had been a lawyer for the movement's most recognizable face, Martin Luther King Jr. Morris Abram was also from Atlanta, and he had served as a trustee at Morehouse College, King's alma mater. He was a founding member of the Lawyers Committee for Civil Rights. He had won landmark Supreme Court rulings, including Gray v. Sanders, establishing the one person, one vote principle. He was also the chair of the board of the American Jewish Committee. He had great experience in international law and affairs. He had served as a prosecutor on Justice Jackson's team at the Nuremberg trials, and he was the first general counsel to the Peace Corps. The State Department then named C. Clyde Ferguson as Morris Abram's alternate on the subcommission. Clyde Ferguson was born in Wilmington, North Carolina, and his credentials were virtually unrivaled. He was the first African-American to serve as the general counsel to the U.S. Civil Rights Commission. He was a member of the NAACP's Legal Defense Fund's board of directors. And in 1963, he became the dean of Howard Law School, the civil rights citadel that produced men like Thurgood Marshall. And so in Ferguson's capacity on the subcommission, he negotiated with UN working committees, and he served as a surrogate for Morris Abram when Morris Abram was absent. Now, the State Department's personnel decisions were groundbreaking. Obviously, these men were immensely talented, but they offered so much more to the U.S. Delegation than their impressive credentials. State Department officials recognized that civil and human rights were not simply moral issues, they were also foreign policy issues. And think about this, the State Department had tapped two high-profile civil rights lawyers, right? One Jewish, the other one Black. They were both World War II veterans, and they were from the South, right? The region so fiercely criticized at the United Nations. Who better to fight the Soviets? And so the State Department made one last major move in preparation for the subcommission's 1964 meeting. The United Nations had charged the subcommission with preparing the first draft of what would become the International Convention on the Elimination of All Forms of Racial Discrimination. And so when the convention was given in first order to the subcommission, State Department officials lobbied the chairman of the subcommission, and they seized the moment. Morris Abram and Clyde Ferguson became the primary drafters of the Race Convention. And when they were presented with this unique opportunity to mold the world's most comprehensive treaty on race, they exported U.S. constitutional law and U.S. civil rights policies. Right? Concepts like equal protection made their way into the convention. The idea here was this: if the convention mirrored U.S. constitutional law and civil rights policies, then the U.S. could argue that it was at the vanguard of racial progress. And so when I began this project, I was not thinking about comparative legal history, admittedly so. Right? I was simply interested in a legislative history of the convention, and then why were civil rights lawyers being tapped to supply the first draft of the convention? But the more I got into the project, I began to understand and really appreciate comparative law and comparative legal history in just very different ways. That at so much of the debates, and as I went through the archives, I saw that American exceptionalism was very much at the core of the U.S.'s mission, and it became center to the debates during the subcommission. And so the Soviets and the Polish, right, they were fighting to advance their ideas of an empire of justice. And on the other hand, you had the United States pushing the ideas of American exceptionalism, right, being comparative necessarily in nature, but putting the civil rights movement at the center of the discourse. This was the move to me that was really unique, that the civil rights movement, right, was at the center of so much of global discourse. And as the South was turning, the idea, the United States' position in the world would also turn. And so, inasmuch as we might consider the subcommission as an apolitical body, right? UN protocol held out that these experts were in their individual capacities. These experts were working with their national governments. They received things like guidance papers. And so human rights became something more than an apolitical legal forms, neutral, universal in character. Right? Human rights was a way to fight out the Cold War. And so for the United States, there was a pattern that emerged that was explicitly comparative in nature. The United States would often put forth its draft of the convention. The Eastern Bloc would respond. And literally the subcommission was presented with a legal menu of options, right? Are you going to take the US route? Are you going to take the Soviet route? Might there be other amendments here that were presented before the subcommission? And again, I had to understand that this was a comparative project, right? That these experts were evaluating the merits of these claims and whether these claims will work first often in their home countries, but then in other areas of the world. This also meant, though, as I looked at the archival record, that the drafters in places like the State Department, but when I went around the world, I found other guidance papers. And these lawyers had to understand foreign legal systems by necessity, but how their proposals would be received by other legal systems and how they would fare in these debates at the subcommission. And the United States, again, very much wanted to be held out as exceptional, not simply in rhetoric, but also in law. And so I'll just flag in my time remaining just a couple of ways where the United States put forth proposals in the subcommission, and that comparative law was just very much at the center. And again, I can give you many more examples, but I'm just going to flag three very quickly in my time. First is special measures. Under Article 1.4 and Article 2.2, special measures, essentially affirmative action, what we understand as affirmative action in the United States, is protected in the convention. And as the State Department was drafting what became the primary draft of the convention, Clyde Ferguson in particular had great experience with this developing form of affirmative action. And he understood that this would have great resonance with people all around the world. He was part of a group of cosmopolitan thinkers, people like Dr. King, who had studied the reservation system in India. And so while it wasn't an apples to apples match, right, we're talking about religion in the context of India, race in the context of the United States, reservations had a great resonance with Clyde Ferguson, and he knew that it would appeal to the Indian delegate on the subcommission. But this was also true for in Africa. There were Africanization programs that were emerging. Even in the Soviet Union held itself out to be this empire of justice, and they were flying Asian, African, and Latin American students to the Soviet Union, providing them scholarships and training them at places like Lumumba University, right? That there was an emphasis here on, quote, underdevelopment. And this went over very well on the subcommission. Clyde Ferguson and Morris Abrams celebrated this as a victory. On the other hand, great failure with Article 4. Article 4 bans hate speech. And the United States, remember at this point in time, this is on the eve of New York Times v. Sullivan. The United States is going in one way with the First Amendment. Most of the world is going on in a different way. And many of these African delegations did not understand why would the United States protect the rights of bigots? Why was the United States so sympathetic to bigots? And the United States lost here, and we can again talk more about it, but this comparative project of why should you have so much sympathy for members of the Klan? The US was outvoted on this front, that the United States did not look exceptional in the ways in which it wanted to hold itself out to be. Last point here, Article 5. Article 5 of the convention, Article 5 of the convention is a catalog of rights. It mandates non-discrimination in civil and political rights, but also economic, social, and cultural rights. But at the core, there was a compromise that it simply mandated non-discrimination in these rights and not full recognition of these rights. This divide had kept ICCPR and ICER from being adopted. Right? And so the lowest common denominator was not to push for full enjoyment of civil and political rights or economic, social, and cultural rights, but to simply mandate non-discrimination in those rights. And the convention moved forward, right? But this comparative project, again, to get around these issues of comparative law, if you had no right to housing in your constitution, then there could be no discrimination in the right to housing. And so the convention went forward. And so in takeaway, when many people think about the genealogy of international human rights law or are considering comparative legal history, the US South is very much not part of this conversation historically, right? The South historically has been rendered as parochial, provincial, a closed society. But as these civil rights lawyers were attempting to transform their region, they were also transforming their nation and the world. The South was the litmus test for many people, right, around issues of democracy and law. Thank you.
Thank you so much, Professor Lovelace. So we now have two questions in the chat. I will present the questions, and then maybe each of you can take a couple of minutes to address them. So the first question is, how did Japan adjust and keep their legal traditions despite the influence of a constitution imposed by the United States? I guess this question is directed primarily to Professor Kim. And then we have a broader question that really speaks to all four talks. Can we do comparative studies without prescribing human rights from an imperialist sense? So maybe Professor Kim, you want to address the question that is specifically directed to your paper first, and then we can open up the conversation on the second question.
Well, Japanese Constitution, post-war Constitution, 1946, of course, was heavily influenced by the US, no question about that. And these days, I think not just in Japan, but everywhere, and almost everywhere in the world, there is something we might call the constitutionalization of law. I mean, everything tends to be interpreted in terms of the Constitution and Constitution conforming interpretation. So US influenced the Constitution, of course, was heavily in Japan. At the same time, now Japanese civil code includes necessarily a lot of elements of tradition, Japanese or the East Asian tradition. So one, I think there is more and more than before the trend of interpreting even the civil law, civil code clauses or the articles in terms of the Constitution. at the same time, well, I guess there's still the difference between, after all, Constitution and private law, civil law, the civil code. So how do they keep their legal tradition? Well, that's a challenge. I think that's for everyone else.
Thank you so much, Professor Kim. The second question is broader and is really, questioning comparative legal history itself, the uses of comparative legal history, and whether comparative studies and comparative legal history is itself a tool of an imperialist project.
I guess I'll just come in here to say that I do think that recent trends in the field have, done two things that are significant in not in direct response to this question, but that indirectly respond. One is that there's a greater attention to the ways that legal practice of all kinds constitutes contributions to legal structures and also contemporary legal theories. And so that there's, less of a sort of a rigid distinction between what you were describing on as global intellectual history and so what socio-legal historians do. There's really a very rich overlap there, so that the kinds of work that Ariela was talking about and many other people are doing about the legal strategies, and I really want to emphasize that legal as an adjective in that sentence is writ large. So it can be engagement with courts, but it can be all kinds of strategic action, opening to the full range of issues that also Tim Lovelace was taking up on behalf of people who are not lawyers, not law trained, but they are, impelling institutional change, political and cultural change through those strategies. That is also a trend in the field. So there's this kind of move towards practice meets theory, in effect, or political thought, history of political thought as a history of practice. Well, I'll leave it at that. That's probably the main point to make here.
I might just say something following on Lori's point, and something I was thinking about when she was speaking. She mentioned work, for example, by Bianca Premo, whose book, The Enlightenment on Trial, looks at claims brought in the Spanish Empire by enslaved people, children, women, many, people who were in traditional legal systems, right, subordinated, but are able to bring claims to legal institutions, and in part, right, in the way that Lori described, right, by taking advantage of the openings for people, subjects of the crown, to appeal to the crown in a way that challenges the authority of colonial legal elites, taking advantage of that multi-cornered, right, structure, and sometimes the contestation of these different jurisdictional authorities. And so, when it came to enslaved people, for example, claiming freedom, which Premo writes about, and of course is our subject, right? You have a situation where, she describes a kind of, vernacular enlightenment, right, of ordinary people making rights, kinds of rights claims, using legal structures not, that are not explicitly about that kind of you know, a human rights regime. In fact, they're often, you know, part of the ancien regime, right? As Malik Gachem is talking about, the possibility, you know, maybe the Code Noir itself could be turned to the purpose of curbing the planters' authority. And so precisely the kinds of jurisdictional tensions, right, that Lori talked about, I think give an opportunity for that kind of, you know, rights claiming from below, that I think doesn't necessarily fit into a model where we say, oh, you know, this is imperialist, you know, kind of human rights discourse that we're prescribing. So I think there are actually some very interesting ways, and it's very much, right, methodologically bringing that intellectual history tradition of looking at the Enlightenment and theories of human rights together with a more socio-legal approach. So just wanted to bring that in.
Thank you so much.
Yeah. Oh,
Yes.
I'm sorry.
Oh, please.
I just want to jump in. I mean, my comments follow both Lori and Ariela's comments. Thinking about this project and Moore Saberman Clyde Ferguson and who they were, right? They're participating in a human rights project, but you have the Dean of Howard Law School, you have a lawyer for Dr. King, and they're involved in this project for a number of reasons. One, you could simply say, you know, they were thinking what was good for the United States was good for the world. That's perhaps one way to think about it, but they had a far more sophisticated understanding of human rights lawmaking. One of the ways to think about this was that it's one thing to violate a statute. It's another thing to violate a federal law. But if the U.S. were actually to ratify the convention would give civil rights lawyers and activists another hook to push the United States to live up to its creed, right? And so in this way, you don't really see empire in the same way. It's far more nuanced. And I think, you know, we can simply think about self-interested rational actors in a traditional Cold War framework. I think that that's important. But to understand the motivations about why these lawyers would get involved in this project. Their project is desegregationist in nature, right? A Black lawyer, a Jewish lawyer, they know what they're getting themselves into, and they're very sophisticated legal actors. And they think that they can do good for the world, but they think that this can also help the struggle at home.
Thank you so much, Professor Lovelace. We have another question, which is again for Professor Marie Kim. When you mention resorting to equity, are you referring to courts, tribunals to hear cases of fairness? I ask this because I know equity is a cognate of the Spanish equidad and likely other Romance languages. That generally would be understood as fairness in common law.
I think the word equity, équité in French, is a little bit different from equity in English law. Now, in England, of course, they needed a separate court to pursue fairness and so forth. But in case of France, the highest court, the Parlement, but he had it monopolized the power to pursue the equity. For example, the judges of the Parlement denied any lower court judges to decide anything on the basis of equity. So the unlike England, in France, it seems equitable solution was incorporated already into the law of the Parlement Paris. And in that sense, I believe the equity is something kind of fuzzy and that kind of appeal to justice, a sense of rightness and so forth is a little bit different from what the French interpreted the équité. So équité in French law was simply to avoid customary law, to avoid legislation or the statute when the judges believed that following these custom or the legislation would result in unreasonable the solution. So équité was, I think, was equated with reason.
Great, thank you so much, Professor Kim. So we have some time left, and I think we have no more questions. So I would like to take advantage of the privilege of being the moderator and sort of highlight a couple of themes that emerged from this wonderful, from these wonderful presentations and hear your thoughts. So from Professor Benton's talk and Professor Gross' talk, really we see the power of comparative legal history as an explanatory tool, right? So a big, larger ideological movement in at the time of the modern revolutions, be the discourse of rights or the discourse of freedom, and how the same universalist and aspirationally global discourse is then re-articulated at the local level by local actors who are moved by different power, different agendas, political and social, actors who also use different doctrinal levers, use different procedural pathways and avenues to obviously reach very different outcomes. Another theme that I think emerged and that is also fascinating in Professor Kim's talk is a wonderful historiography, comparative historiography of early modern France. So how French historians, with the big division between more traditional doctrinal legal history and the cultural history of the Annales years, and American historians who have a more sort of methodologically capacious idea of history, and also one that is focused specifically on the question of power and power hierarchies. These different methodological traditions in France and in the United States have looked at the same historical period, early modern France, and in particular the question of custom and the traveling of custom to the peripheries, with very different, offering very different perspectives. And finally, in Professor Lovelace's talk, comparative law as a tool. Comparative law is a tool that allows us to see in this fascinating history how two prominent local actors in the south of the United States, one Jewish and two prominent civil rights lawyers, one Jewish and one Black, actually sort of articulate a craft, a narrative about American exceptionalism and about human rights that is then used in a larger geopolitical power struggle. Yeah, I would love to hear your thoughts on one or any of or all of these points.
So can I jump in here? Because with respect, I'm going to resist your characterization of at least my approach, and maybe Ariela will allow me to include her, of our looking at what's happening as a re-articulation of a kind of universalizing narrative. It's not that at all, right? Because in fact, what we're describing is the creation through legal politics and a kind of thick discursive process in multiple places, it turns out in these imperial settings, is actually creating and shaping a different discourse about rights, a different structural relation of rights to order, a different set of practices of freedom in Ariela's and Alejandro's case that than one would get if one looked at the sort of standard narrative. So I really would like to emphasize that, right? It's not a question of having these dominant strands inflected in and by local actors, not at all, right? They're not following a script. They've got something more like a loose repertoire, and that repertoire is much wider than we have traditionally thought. You know, sometimes it's narrowly legal, but sometimes it's only sort of vaguely legal. They're going off, you know, what they think the law is very often. But so I just want to emphasize that. What I took away also from Tim's presentation, which I thought was a terrific reminder and something that I left out, but Ariela did not leave out, but it's very important in the imperial settings too, is how implicitly comparative this project was. That legal actors were themselves, you know, the classic case of sort of the Atlantic revolutions, where they're but even before that, well before that, these imperial legal settings people are very aware of what's going on to the extent that they can get information about it elsewhere. And sometimes they're really self-consciously mimicking that or coming up with languages that they think are going to position them internationally. So I actually thought that was a really interesting commonality, although it's not something that I stressed, between, you know, this you know, 20th century analysis and much earlier analysis. If I can just squeeze in a really quick question to Mary Kim, I would say I'm really curious to hear what you think about this, you know, revived debate about Alexandrovitz, because in a way, you know, the whole, you know, there's a whole wing of the field of the history of international law that's moving towards actually looking at custom as something much older than you described it in your account, and something that we could think about maybe with a different name, as going back to interpolity legalities well before Asian interactions with Europe.
Oh, custom can be anything, right? It depends on how you define it. Well, we typically say, well, there's a custom for sociologists and there's a custom for lawyers. But in my opinion, as long as what we are doing is studying the evolution of law, there has to be some boundaries that we abide by. Otherwise, I'm afraid the law just loses any meaning. According, well, if you follow this analyst broad definition of law, any norms can be custom. So I would rather put some boundaries on what custom means. That is why I kept saying the custom as a law, or custom as a source of law. And now, my observation in this panel is, of course, in comparative law, there's we place very much emphasis on the spread of legal ideas throughout the world. There's a spread of Western legal ideas. And they, of course, it took place in terms of colonization, imperialism, domination of hegemonic tradition and so forth. But I think maybe the idea of this imposed reception has been a bit overstated, simply because I believe that legal transmission or the transplantation takes place on the basis of a choice rather than force. When a alien legal tradition or the system can take place or take root, it can take place only when it is accepted by those who are subject to it, no matter whether it has been imposed by force, by colonial power and so forth. In other words, when the subjects understand or realize that this new alien legal system is persuasive, then there is any possibility for that system to take root.
Thank you so much, Professor Kim. So we are slightly over our end time. Thank you so much to the 4 panelists. Thank you so much to Professor Maximo Langer again. And thank you to you all for being here today.
Thank
you. Sorry, team, that there was no, I would have left. I don't know if you, wait a second, let me stop this.